интеллектуальной собственности, и именно поэтому
And this is why we have here representatives of various executive bodies who, together with Rospatent, are working to provide answers and solutions to the topical issues of today. We also summon here the business community and our applicants, and also we provided for the participation of the professional patent attorneys in our meetings so that we can discuss the regulations of today. I would like to introduce our speakers today: Natalia Zolotykh, Vice President of Opory России and Head of the Public Council of Rospatent; Sergei Shklyaev, Head of the Department for Trade Restrictions, FX and Export Controls of the Federal Customs Service of the Russian Federation; Boris Gerasimov of Sberbank; Olga Kravtsova of the Director of the Department of Rospромторг; Some Tikhonov, Director of the Department of Strategic Development and Innovations of the Ministry of Economic Development; from Gazprombank, Dmitry Markanov, the Managing Director of the law firm. Now, welcome you all here. First of all, I would like to ask Natalia Zolotykh and inquire what are the challenges of today for SMEs, and you as a good example of the Quality Council of Rospatent and the Council for IP of the Council of the Federation probably know quite a few things about the recent development trends of the IP institution, not only in terms of the protection of the IP rights, but also in terms of the tax incentives that are being provided. Perhaps you can share with us the most recent trends in regulation. Thank you, Victoria. Indeed, I thank Rospatent for organizing this representative forum. This is really an iconic event, and today we can say that what is relevant today would not be only narrow issues of IP protection, but we can take a broader look at the practical challenges that are relevant for business. And indeed, of late we have seen some significant changes in the IP legislation, and these changes have been guided by the adoption of the roadmap, which is being implemented as part of the special project of business climate transformation under the auspices of the Ministry of Economic Development. Indeed, this is a unique venue, a unique platform. This is the venue where the business community and the public authorities can discuss the barriers to the intellectual property activities and find the most efficient ways of overcoming such barriers. It's a good thing that the IP roadmap can be supplemented and altered if needed. And indeed, there was a task of identifying the tasks and goals of this roadmap. Unfortunately, even today, we do not have an IP strategy or IP development strategy. And there has always been an issue. What way should we follow? What would be the goal that we should be following when we are adopting this or that law? We think that a clear definition of the tasks and goals would make our work more efficient. It is good that as part of this program, we can implement a comprehensive approach related to the various aspects of the IP protection and putting the innovations into the civil domain. And for SMEs, it has always been important to diversify their businesses and to make them more innovative. And one of the barriers was that for a long time now, the public educational institutions have not been able to claim the rights on their products and to invest them into the existing companies and into any newly establishments. Or rather, they were able to do that, but only on the basis of a license agreement, and the alienation of those rights was not possible. But indeed, the Opore Rossiya believes that we should, especially today, we should provide some freedom of entrepreneurship, because only through the provision of a license to the outcomes of intellectual activities would not be an incentive good enough for business to invest money, skills, and time into the advancement and the fine-tuning of a technology. Well, it seems that the ice is breaking of late, and that we already made our proposals on the score, and we think and hope that quite soon enough universities and think tanks will be able to keep the rights and to really invest those rights into any companies and get some benefit on those. However, at the same time, we are suggesting some other bills. For example, one of the other documents that are being reviewed as part of the Business Climate Transformation Initiative is a document that lets inventors the right to acquire exclusive rights where the invention was used for the production of any final products. Well, the main purpose of the authors of this bill is to incentivize the authors to letting them use their knowledge products for commercial use. Now, of course, even public educational institutions cannot invest their products of knowledge into companies, and there are no good business circumstances for investment. And in this environment, it is a question whether we can implement this idea in relation to the authors of various inventions. I don't know how it should be done in practice. Many mechanisms that, with the support of Rospatent, have been actively being supported, including in getting a loan with a pledge for the IP rights. All such initiatives are going to be constrained. All those tax incentives would also be restrained. I'm in favor of supporting the authors, but perhaps we should be quite careful in choosing the legal instruments that are being provided. We do understand that the result of some intellectual work would be improved and maybe changed. We are thankful for the changes being made to the Russian law, and in particular, we are thinking about changing the law by providing a 5-year term or for SMEs or a 3-year term for other companies, granting them with the tax privileges and incentives on their R&D and activities and outcomes. The paragraphs 12 and 14 of the roadmap provides for the development of 2 federal laws which would which would offer some exemption of the persons of the CAT and VAT. I'm not going to develop on the tax incentives, but what is the main problem today? Business is really worried and concerned today that it is kicked out of the chains that have been developed until today. When we're talking about SMEs, indeed, it is innovative and it is export-oriented. And these are the companies that were built into those global chains of international cooperation, and they really had some commitments to sell certain parts and components. But fortunately, they're out of those chains now. There are some hopes that we are going to launch some parallel import mechanisms, but frankly speaking, I do not really believe that this instrument is going to offer a real opportunity for import substitution. And perhaps the only way, real and good way, for the companies, and companies do appreciate that, is to really anticipate imports. So it's the question of using the IP products, including patent rights, in the event such are needed. And actually, we have that in the existing law, the Article 1360, which talks about mandatory licensing. That is an available instrument for such anticipatory patenting and activity, and we need to use the opportunities offered by existing law and move on. Thank you, Natalia, for your very intensive presentation. And indeed, as of today, we have this roadmap, and that roadmap, in its 2 years of existence, made it possible for us to take a step forward. And whatever is put into this roadmap made it possible to adopt a federal law which authorizes outsourcing and the use of certified entities. We now have a new dispute settlement procedure in place. We joined the Lisbon Agreement, or Act, if you like, and we move on with our work to improve regulation. And Georgi Kotler is online with us today, and we work with his department to work out the key initiatives to improve the IP protection system. Perhaps I would ask Georgi Zaurovich to talk about our future work to improve the IP institution and about the outcomes of our recent efforts. Victoria, hello, and hello, colleagues. And yes, indeed, I thank Natalia for her short description of the available mechanism. And this mechanism indeed was established 2 years ago. And this is a strategic document which includes tasks and goals and the KPIs that are pursued by the public authorities in the domain of IP protection. And the roadmap is being implemented with the help of the business community. We have an expert group established to include many entities and institutions, including patent attorneys, corporates, and public officials. And through their effort, we can develop some promising decisions and well-weighted solutions to really provide for a balanced piece of law. And the engagement of the Council of the Federation, the Ministry of Industry, the Ministry of Higher Education is also very important. We already have 9 federal laws in place, as approved, 6 Cabinet of Ministers resolutions and a number of departmental instructions and guidelines. And we are working on a number of new initiatives, and indeed we are discussing quite actively and updating the various events. We have some instructions to work on any contribution from the Russian Union of Industries and Entrepreneurs into that roadmap. The current work is on the provision of tax exemptions that Natalia described. Those tax benefits will cover the IP rights that were identified as part of the stock taking in the companies, and I would hope that this should be a very serious effort. We hope that this law would be going through the second and third readings, and since the term is quite limited, and the law would be put into force as of January 1st of this year, for 5 years for SMEs and 3 years for the other companies, I think that then we should really accelerate our efforts and really take stock of the balance sheet items that the companies have, and then come up with the portfolio of their assets and grow one of the components of those assets, and perhaps through that we can provide better protection of IP rights, etc. Second point, which is very important, and again, this is a draft law which authorizes citizens to register their trademarks, and that same piece of law provides for the pledge of the registered trademarks. And for citizens, it is well-awaited need, because we have many self-employed, and there are a number of persons who are providing their services under civil law contracts, and it is also of value for our long-term development, and should be of value for broad community. And a third important initiative, which is included into the roadmap, and which is being actively pursued by the businesses, is the ability to register trademarks which contain the geographical attributes, and this is done to avoid any confusion among the public. I separately would like to highlight a number of actions. We have some tax actions or taxation actions, and we have other activities that would supplement the others. And I should say, if you take the taxation domain, there we have 5 activities that can help the businesses. The stock taking of assets, which I mentioned before, and the measure that has been already implemented. And this is about the commercial concession agreements, and there you may identify the IP outcomes that are not subject to VAT, as under license agreements. So if you issue documents about franchises, you no longer need to issue another license agreement on concessions. The measure has been suggested and approved by the President and would be enforced soon. 3 more important stories: the exemption of the CAT. This is a CAT exemption and VAT exemption for persons when the rights are being transferred by the state free of charge to such a person. Another story is the resolution of various tax issues related to the free transfer of the rights within a group of persons when a company A in the same group transfers the rights, IP rights to company B, then the company A runs into problems because this is a free transfer, and then the question is why the commercially oriented company would issue something for free to another unit. And the company B, in turn, has also some issues of taxation, getting something for free from company A, and the company B needs to pay a tax on such free rights received. So we are going to resolve this issue. Also, we want to have 2 more initiatives to be in place about the patents, and we discussed that with the Ministry of Finance and the Council of the Federation. The Council of the Federation did monitoring of the situation.
The first reading was introduced into Russian legislation last year, and it had to be included by the decision of the region. But for the moment, until the moment, nobody used this vehicle because it left a lot of gaps, which has to be breached by the decision of the regions. Now we propose another scheme. If a company separates or segregates some license payment incomes from the results of the activities of entities registered by Rospatent or registered by foreign patent authorities, such IP objects can be subjected to the CIT tax at 3% rate. This measure, as proposed, can be introduced by the region. On the federal level, there is a framework, and each region, depending on its opportunities and capabilities or budget deficit, is able to acquire some registration opinions or introduce this tax subsidy. Also, we work on a number of other taxation mechanisms, but I think it's better to discuss them as a result of the decision of them. Unfortunately, we have a tight schedule today, timing. If just 1 more minute, please use this minute. We're ready to listen to you longer, of course, but well, unfortunately, we are not able. Let's give also the opportunity for other speakers to present. Okay, I'm ready to handle the questions then. Thank you. Thank you, Georgi. Now let me please resort to the practical part of the operations of our authority. It's clear that we are dealing with the improvement of regulatory mechanisms, and we are discussing it today very actively. We have questions from our applicants. The needs which arise are related to this accelerated consideration of application with the improvement of expert opinion examinations related to right protection also, but we are not halting and staying with the successes we have. We're not complacent. Just recently, this year, an Advanced Technology Improvement Center was established under FIPS, and we'd like to pass the floor to Mr. Neretin, Director of FIPS Institute, to share with us the main principles which this expert center will be handling, how applicants can use the benefit of it. Please share with us these initiatives. Thanks, Victoria. I had a presentation. If we can bring it up now to the screen, would be great. Thank you. Dear colleagues, it is true, this year we established this center, and the reason to establish this center were a few preconditions. I'd like to start with probably the longest event which been haunting by for many years, especially during the COVID time, which made us stronger and more skilled and experienced. And I'm going to tell you more about it. When this long story started, as it turned out later, already back in April 2020, we started to consider all applications for utility models and utility designs related to COVID in a priority mode. It allowed us to develop the special working mechanism. As you can see on this slide, you can see the figures, you can see them all. I'm not going to read them aloud. One of the figures is basically 28 days. 28 days was the time needed for the first action to consider such applications. And that allowed us to register first patent for coronavirus vaccine. We registered this vaccine at that time, and based on the example of working with the National Research Center of Gamaleya for epidemiology and microbiology, we worked out a comprehensive approach to the patenting strategy. On the screen you can see that basically the protection of this technology and the protection of the whole process, which entailed the vaccination later on, embraces 9 patents. Of course, everything started with the first one for the active substance. And working with our experts, the employees of our center and the developers of the vaccine arrived at 9 patents, including the active substances and administration methods. The whole comprehensive patent, the whole comprehensive system which protects the whole technology, if we can call the vaccine the technology. Moreover, we did everything from our side to send this patent for the international registration. This year, due to a number of other reasons which are well known, we established a center which is aimed at the following: to establish conditions for technological leadership, supporting different organizations to develop innovative products and develop key technologies to develop. The result should be an accelerated way to the market of new products, and I have to stress that the result of all these activities should be the maintenance of intellectual sovereignty of our country, to master and to support critically known and all important technologies be in the scope of Russian right owners and producers, because amid sanction pressure and given the acute need for import substitution, this task has a critical importance. What are our main areas of work? First is healthcare, IT technologies, microelectronics, aviation technology, road equipment. The first item is very important. Healthcare means cooperation with our partners on the premises of whom we are located. The Moscow Healthcare Support Center, this is the entity we are going to collaborate in future, and we already are cooperating in different issues, and the issues which we are addressing are included in the functionality of this center. As you can see, comprehensive study of the patent portfolio of the company, if any, detection of technologies free of third-party claims, re-engineering technologies, developing of patenting strategy of invented technologies, and pre-assessment of patentability during design. It is not contained on this slide, but we have to add also some information that, yes, we confirm that we are ready for re-engineering regarding the import, which was regarded, the substances and everything else. And so in this case, we are ready to work with the producers to make protection of technologies, of Russian technologies, which would replace Russian for foreign technologies and different goods, which would be then protected by our patents. I have 2 more slides. This is about re-engineering and the ability or inability to work with this substitution. As an example, you can see a Tetra Pak. No, sorry, that was just a different one. Yeah, unfortunately, I got only 2 buttons here. So Tetra Pak in Russia, 294 patents registered. Practically everything which is possible was patented, and as a result, it prevents from producing this product without violation. But it's not an overarching example. The second case is better here. These IFA analyzers, despite the 77 companies of 25 countries deliver their products to the Russian market, only 10% of them, 13%, only 13% of these patents are registered in Russia. These IFA analyzers can be produced in Russia without violating any rights, because we have patents for that. And which is called now more and more with the world re-engineering. I hope that this process will be more active. This consulting will be accelerated. Yesterday we had a meeting with agro-engineering companies, and this procedure will be interesting for all producers who will be willing to work in the market in import substitution projects and be absolutely protected in terms of their rights, being sure about the opinion of the expert community and patentability of their solutions. And now I'm ready to handle your questions, if any. Thank you. Thank you very much, Oleg Petrovich, for your very extensive presentation. And I'm sure that many applicants, many listeners of ours will be really interesting to learn more about the activities of your center. And I do hope that because of your center, we are able to attract attention of big applicants, representative of different industries, and owing to this activity, we can increase the amount of applications for trademarks and for other items of IP right. You already touched upon the topics which we've been discussing very often. This is the acceleration of application consideration. We had a wonderful experience in this area, especially in pharmaceutical and healthcare. We do see real results in this sphere, and we managed to reduce the consideration time as much as possible without any detriment to the quality. In terms of pharmaceuticals and medicine, the most demanded areas are the areas of IT industry. And we at Rospatent, at FIPS Institute, and other specialists and experts in this subject matter from the Society of Patent Attorneys, we decided that it's necessary to establish a task force which will be responsible for improving the methodology in patentability evaluation for IT solutions, which will be devoted first and foremost to the fact that this sphere from day to day is gaining more momentum, and those approaches which used to exist some time ago, and we fixed in our legislation and regulations, now due to the modern level of development of equipment, are not able to describe completely the tasks which are now in front of this sphere, including the issues of evaluating what is a technical solution, what is a technical task, if an invention is based on the use of the artificial intelligence and other areas of the IT industry. Today at our panel we have Boris Gerasimov. As already introduced our colleague, I'd like to ask Boris to tell us more about the experience of Sberbank in IT solutions patentation, and what is your opinion? Shall we speed up this process or shall we address other issues? What is your stance on the establishing of our task force, and what perspectives you see in this regard? Thank you, Victoria. Many thanks for your moderation and for this wonderful opportunity to express my opinion for the business, for the company, for FIPS, and to patent attorneys. It is really precious. I'd like to I try to be concise. We've been dealing with patent landscaping, with recognitions in this area and what happens in this sphere in Russia. Unfortunately, in the Russian Federation, we see more and more patents of our foreign partners. And if we make a cross-section by classes of different spheres and take the top of 10 right holders in IT sphere, unfortunately none of the Russian companies are presented in this space. If we take a look at fintech technologies, how many companies, how many products are patented in this sphere? For example, Sber has more than 300 patents valid and more than 600 applications. If we'll take a look at other banks, VTB has 11 patents, 7 of which are utility models. Tinkoff has only 1 utility model patent. Alfa-Bank, Otkritia, no published patents at all. Fintech companies working in the Russian market, they are practically not patented, and this is probably a technological disaster, if you may, because these bubbles are growing, patent bubbles are growing in all industries, and at some points our foreign partners would decide to sue us and go to court for royalty. We will just be overwhelmed with all those suits. We will have to redo all our technologies, because in the DNAs of our right holders in IT, there's no mentioning about that this is their right for their invention. This culture is more really spread in the US or in Asia. But patent trolls are coming to us already now, not in the format as they come to the US. It's not 300 lawyers or technicians and who buy patents, write patents, and go to court and win the court suits. These are so far individuals who create something and that's something, and it's easier for us to protect them ourselves from them. But if the trend would grow, Russian right owners in IT will have really hard times. In this sphere, we also faced another problem. The problem which used to be in the US around 10 years ago. If you remember the precedent case of Ellis Corp and CLS Bank International, when nobody understood what is an abstract idea and what should they do when an applicant tries to patent any algorithms without any hardware. In Russia, we are approximately facing the same story. We don't have methodology or IT solutions, and especially for that, the task force was created with a lot of professionals, but we have problems with the operational activity methods. And probably this is due to the fact that applicants try to be very abstract in the applications. It's very hard to enter. They try to add on an AI and think this is patentable.
And the practical expert examination tends towards Europe now. We think that this is quite a wrong approach, because in Europe, if you take the IT legislation, and the patent law is the toughest one. It takes 3 or 4 years to really have your patent in IT approved, and it's not really given that you will. Question is whether you can patent software. Well, some people are trying to refer to Article 1350 of the Civil Code of Russia, which says that such software patents are not forcible. And so if you don't have any expertise in patenting such products, then this edge between what is patentable or not, it's a very thin line. And people often face that this is the software, and this is where all the disputes begin. In Article 1315, the programs for computers are not patentable, and they are not patentable across the world as such. In Europe, in the European Charter of Patent Law, in the US, etc. But algos can be patented, and of course we need to move on to work with the professional community, with Rospatent, and find a methodology of patenting the IT solutions. And we also think that we need to move along the way of China, because in China they have very strong subsidies and exemptions for patented IT solutions. In Hainan, for example, an IT company which has a patent portfolio can receive $72,637 US dollars, almost 80,000 US dollars, just for a company which has a portfolio of patents. In Bloomberg, there was a recent article that the 2 million patents in China is false, because they use sometimes patent solutions that are not really industrialized. But the subsidies and endless support from the state and exemptions really make it possible for companies to move on and to go forward. The companies are interested in receiving patents, and if you take the court practice, then 99% of the foreign companies do lose in Chinese courts, regardless of their patents, because the patent landscapes in all sectors are so much rich and filled with Chinese patents that no foreign company can enter the market. But if you take our field, then indeed in Russia we have many more foreign competitors with patents, and we need somehow to harmonize the patenting experience. Statistically, China, which is implementing such a support mechanism, is very far ahead of the rest of the world in terms of the patents portfolios. If you take AI, China has 8 times more patents than the US. The company called Consent has a portfolio which is 3 times Tencent, which has 3 times more patents than Facebook, or 2 times more than Amazon. This is a super company in terms of patents that they are registering there. Through this, you grow your company, and through this, some startups really want to enter the market of receiving patents, and this is the way we also need to follow. Yes, you had a question about accelerating work, and we are accelerating almost all our applications because Sber has 12 innovation labs in charge of various sectors of the economy, and those solutions are being integrated into the infrastructure of Sber and really deployed in the market. So we are very much interested to do that, and we are thankful to Rospatent and FIPS that the procedure is really ideal. And the first reaction is not only about pharmaceuticals, but even in IT, you have the first feedback within a month, and then you can start your life story of examining the applications. Thank you for your contribution, and indeed, in addition to having a larger patent portfolio, you also need to have some anticipatory applications, so that it is those patents would not be about any minor fixes or improvements, but they should be about some really innovations. And our working group is there to develop such support mechanisms that would in part explain to our applicants and to our law enforcers what could be a technical result, what could be a technical innovation, to avoid this restriction of paragraph 5 of Article 1350 of the Civil Code of the Russian Federation, whereby the algos and software products are not the IP rights unless the application clearly describes that. As such, this, whether a solution is an algo or whether it is a technical solution and how to distinguish between them, this is actually the focus of our experts. Thank you for coming to our panel today, and then we continue our law enforcement discussions, and I would like to ask Dmitry Markanov, who being a managing partner of the law firm, is also a vice president of the Russian group of Association of IPPI, if I pronounce it correctly. And the reason I like the name is because this association is a very active contributor and player, and we also communicate with in different business fora and conferences, and this association indeed draws many experts from across the world to discuss in relevant issues of law. But Dmitry, I have a different question for you. You, as the representative of our applicants, perhaps you and attorneys, perhaps you face some challenges in the last couple of months because of the circumstances, and you probably received questions about the possibility of registering trademarks of the companies who suspended their local operations or left the Russian market. And the question is, how did you, whether you perhaps you discussed the legal protection of Coca-Cola or any other famous brands here. And I wonder, what are the issues that you face today, and what are the challenges that the applicants are raising, including in the interaction with the foreign patent offices and counterparts. Indeed, here I represent not my company, but rather the community of patent attorneys, because IPPI is the largest association of the kind, and I also represent here the International Trademark Association, where I'm in charge of the committee of countering the faked products. And perhaps I'm not going to discuss what is black and or white, but the first experience that the business community had, whether local business or the enemy business in commerce, were the letters and questions whether IP protection was lifted and cancelled. And the first thing that we had to do in February and March was to explain to business that the intellectual property is not cancelled as a concept, and we did not have enough probably feedback. And here I'm thankful to Rospatents because it explained to the business community what was going on, provided the feedback and the changes that were introduced by the March 8th law did not really cancel the enforcement of patents and trademarks, but provided more opportunities. The resolution of the government of March 29, it really left us kind of like without understanding fully what could be the exemptions under law. In the March 18 resolution, paragraph 13 of Article 8 said that some of the civil code provisions may not be applicable, including in relation to IEP. This may be broadly interpreted as covering not only grey imports, but also may raise issues about the proper protection of patents and trademarks, because the article did not say that whether we were talking about foreign trademarks or foreign patents, or was it only about the local ones. But now the businesses do understand the rules of the game, and here we are talking about legalizing parallel imports, but not in full, but on some items. And for some items, it should be an economic approach rather than a legal one, because parallel imports is about the economy, not about law. The country may decide whether it would prefer to authorize parallel imports or prohibit it, offering the businesses to invest into new productions locally. By the end of January, actually, we developed a very good approach with the law enforcement practices and the Federal Anti-Monopoly Service that the parallel imports may be allowed, but there we need also to be guided by the actions of the IP owner and by the actions of the importer, and also assessing the quality of imports, because some of the imports are not really designed for the Russian market, like, I don't know, a rubber gasket, which may be on sale in Saudi Arabia, but perhaps that gasket is only tested for very high temperatures, like plus 40, but it would not be operational and be in good working order in temperatures below, say, 40 degrees centigrade. So this is why we need to decide on that. And of course, we had two examples to be discussed to discuss the Mercedes case and the QIB case. But after the known events, the situation changed, and then we had to authorize that parallel imports of certain items and maybe be easy on the patents. But the law in the resolution, the subsequent resolution, does not say anything about the software copyright, so whether we can buy a piece of software abroad and bring it into Russia and sell or use it. You know, many software developers are leaving Russia, and formally the situation is still hanging there. The next challenge is about the forced licensing. Indeed, we provided for a zero rate for forced licensing, but the old mechanism of getting such a rate still remains. You need to prove that 3 or 4 years that product was not in use, and you need to go to court. But why not change that? Perhaps Rospatents can issue such forced licenses, or maybe the Ministry of Industry and Trade can do so. And that would be the IP owner's charge to prove in court that the owner did not leave the Russian market and that its solution, its product, is being used in Russia. What Valery said, I can complement with saying that it is more important sometimes to register a piece of software in the register of the Ministry of Communications, of Telecommunications, and this is actually a key procedure to recognize Russian software being Russian. And your center, I think, would be proper to work with the Ministry of Telecommunications to provide a more loyal approach to the registration of such Russian software. Yes, indeed, we have several thousands of programs being registered there, but Boris is nodding. Indeed, it is quite difficult for the developers to register their products and to help understand what a certain program is about. Takes a full team of software writers and lawyers. I hope that the IP would not be cancelled, and the number of applications for Coca-Cola is going down, and I hope that Rospatents would be balanced in its approach to the examination of every application and will not allow registration of very similar brands. Just like the country in general, like the customs service, would be still taking actions to prevent fake products. For example, we don't want any low-quality goods like medicines, for example, to enter the country, or automobile spare car parts. Parallel imports would be about the legal products produced abroad and imported parallelly, in parallel to the country. So I hope that the faked items would not be licensed and would not be allowed, but we need to really go hand in hand with the businesses in terms of their education and training. Rospatent last year launched several programs for students, for college students, on the evil of faked goods. Indeed, it is very important to have a feedback from the applicants, from the attorneys, and the system of intellectual property would not be abandoned or cancelled. And the Minister of Economic Development, Maxim Reshetnikov, said so earlier today, that we would be providing similar protection to local companies and to the output of foreign companies. Parallel imports and the provisions of Federal Law number 46, which was adopted on March 8th of this year, all of that provides some different interpretation of it. And also we have a resolution of the Russian government which says that a list of the goods would be compiled, which would more or less be guided by the law exhaustion principle. Sergei Shklaev, maybe he's online with us. Sergei, hello. Actually, we are now talking about parallel imports, and we would like to hear your opinion about parallel imports. How do you see the implementation and the enforcement of the mechanism provided in that resolution, and what would be the challenges for the IP right owners? Because there are proponents and opponents of parallel imports. And undoubtedly, for the owners, there are some issues remaining, because there are some concerns that this may indeed draw into the market some faked goods and any of those associated problems. Victoria, good afternoon, and dear colleagues, hello. First of all, let me thank you for being invited here to take part in the discussion. Quite fairly, this issue of parallel imports has been discussed in the Russian Federation for quite a time, not only in the Russian Federation, but it is also a point on the agenda of the Eurasian Economic Commission. We are discussing that with our partners, members of the Eurasian Economic Union. And the agenda, which is being discussed on the application and implementation of the parallel imports, and this is the exhaustion principle, which has been discussed quite for some time, since 2014, and with certain options there, and at least it was part of the construct of the legal and regulatory acts. Today, the unfriendly actions of the United States and their like-minded countries led to the fact that there should be parallel imports in the mind of the Federal Customs Service to ensure the continuity of businesses, of especially industrial projects in the Russian Federation.
I have to stress that we are now speaking about original goods, and I absolutely agree with the previous speaker that the issue is not about the opportunity to import to Russia of counterfeited products, low quality and not safe products. Here, I have to, set the record straight for all the participants of today's meeting that to make a decision about the opportunity or ability to import to Russia products in the framework of parallel imports does not say that we can allow counterfeited products or fake goods here. Our authorities will work on this track to combat counterfeited imports. In our activity, we use the main institute, the main vehicle, which is the Customs Register of IP rights. In this register, we have almost 3,000 trademarks legally protected in the territory of Russian Federation, included in the Customs Register. And so, if even in figures, as for now, the customs authorities detected more than 5 million items of counterfeited products, which is already accepted and confirmed as counterfeited by laws, by courts. We will have all legal vehicles and law enforcement agencies to combat counterfeited imports. At the same time, we should apply all laws and statutory instruments confirmed by government and the order of the Ministry of Industry and Trade, according to which we are going to enforce these laws and statutory instruments and provide parallel import to the territory of Russian Federation under these provisions. Using the simple words, to make it simple for the audience, we should say that for today, the role of customs bodies was the following. When we see signs of moving goods by unauthorized entities, the customs service suspended this activity and informed the right owner that at that point of time the goods a batch of goods is being transported, and the entity which is moving the goods is not assigned as the authorized importer. We have to inform about it. According to the law, we waited for 10 days from the right owner. If the right owner managed to solve this issue in court and get some provisions of the court on that, later on we followed this instruction of the court. If not, the right owner within the civil rights relations had the opportunity to go to civil courts, and the customs authorities then released these goods in the territory of Russian Federation. That was the role of the customs body when the Intellectual Property Right Protection Institute was working. In this regard, I'd like to stress once again, to understand for everybody, that our legal enforcement practice by court was not ubiquitous. There are court decisions and court practices before making the decision about parallel import already produced their solutions towards and regarding the participants of the foreign trade activities. Already this year we had decisions by court saying that some products are counterfeited and subject to destruction, although they is not counterfeited and original. Although the practice was not the Russian Federation government produced an instruction which allowed us that the original products imported without the consent of right holders will not be considered as a violation. We, as customs authorities, will provide enforcement of this provision due to the executive order of the Ministry of Industry and Trade, and for this time it would allow us to provide the interest from the business community, and we really accept a lot of requests from the importers regarding the fact how can we already begin importing original goods. This is related first and foremost to electronic equipment. We have very brilliant examples on turnover of computer equipment and smartphones. From our side, we inform the participants of economic activities that adoption of these legislative acts allow them to import original products and later on also get some clearances from the customs bodies. So briefly speaking, on the parallel import, the situation is the following. Thank you. Thank you very much for your introduction. And I think that the stance of the authority concerning parallel import and the explanation regarding the fact that this is about importing original products is really critical important, because even among some legal resources we see not quite correct discussion regarding facts that some IP rights be violated, but this is not true. Thank you very much for your contribution, for your time to be part of our panel discussion. Now let me move to our next speaker. I'd like to resort to the representative of Ministry of Trade, Olga Kravtsova, Deputy Director of Pharmaceutical Industry. I hope Olga is online. Hello, Olga. I'd like to stress that Ministry of Industry and Trade is one of our partners in a number of issues, and we've been dealing with issues for many years in the area of rights protection for intellectual property regarding pharmaceutical goods. And especially in 2019, an intergovernmental commission was established on right protection in the pharmaceutical industry, and the department was one of those initiators to establish this task force. We see some results already, and one of the results is the initiative to to set up a pharmaceutical register of active substances protected by patents. I'd like to ask Olga to share with us latest trends and support measures of pharmaceutical industry translated by Ministry of Industry and Trade. What do you think about this trade register and continuing discussion which has been started about the parallel imports? I'd like to listen to your opinion regarding the opportunity of parallel imports of pharmaceutical goods. Olga, please, you have the floor. Good afternoon, dear colleagues. Good afternoon, dear participants of the conference. Thank you very much for this kind invitation to take part in this event. And let me tell you more about the results of our work. It was already mentioned some words about import substitution, import advancement. And it is very critical to understand that economic issues sometimes go to the forefront. And in addition to the information provided by Sergei Vladimirovich, I have to note that medicine and medical equipment, medical substances, are not subject to the instruction of 506. Why is the position like that? Everyone knows that medicines and medical equipment is a category of goods which directly impacting the quality of life of patients, of people, first and foremost. And so here we see big risks if these products be included in this list. For the moment, the handling procedure of these substances is clearly fixed in the legislation accepted at the level of the Eurasian Economic Union. Medical equipment and drugs have to be registered in order to be able to circulate in the territory of Russian Federation. And producers, who are first and foremost right holders for trademarks or their authorized representatives, have to provide state registration of these goods or medical substances. In course of this registration, the product should be confirmed by the criteria of quality and safety for those products and goods. On top of that, there could be specific for the Russian Federation requirements and specific peculiarities. In this regard, medical equipment and medical substances could have some differences from what is allowed to be circulated in different territories, in other territories. A very transparent example, this is the marking information. In order to apply or use the goods, the products, people should understand how to use it. They should have an instruction written in Russian and they should be able to read it. That's first. Second, the producers and authorized bodies are liable and provide conformity of delivered products with the registration documents, which contains requirements for quality and safety. Producers should provide proper conditions for transportation and storage of medical substances and goods. Producers must guarantee proper service and maintenance of medical equipment or provide necessary monitoring of safety and pharmaceutical supervision. And in course of the parallel imports, all those aspects mentioned above could probably be not possible. And this position is very clear regarding medicines and medical equipment will not be in this list, and the provision 506 will not be applicable for them. This is first. Now, what about the register, the pharmaceutically active substances register? A very important project, a very important draft of federal law produced by the Ministry of Economic Development, which is called On the Register of Pharmacologically Active Substances. Everyone understands its importance and criticality, which is which results from the needs of developers and producers in terms of strengthening protection of intellectual property rights, in particular concerning pharmacologically active substances. And this enforcement, reinvigoration was proposed in the framework of legislation improvements. The register of active substances should ensure proper access of actors in the pharmaceutical market to the information about patents existent at the moment. It should also ensure storage and processing of this information. The register should interact with other information systems. It is proposed to be implemented. And for the moment, the draft law is under consideration. And in general, we expect to issue it. And it's going to be a very important stage within the life cycle of our pharmaceutical community, because it is aimed at its task is to provide a certain balance between the organizations who are involved in their own developments, who patent their own active pharmaceutical substances, and those developers and designers who are ready to develop generics and should understand what is their time period, applicable time period, and what documents they should be guided by. Thank you. And of course, and one of the most important moments which needs to be addressed in the legislative practice, and I think when designing this draft you will take it into account, how this register how this register can provide the opportunity to improve rights, to protect the pharmaceuticals, and how to simplify the legal protection procedure. And also one of the issues which is on the table now by Pharma Ministry, whether this pharmaceutical register be applicable in the territory of the Eurasian Economic Union. I'm not speaking about the national pharmaceutical registers. I mention now, and as you mentioned already very correctly, there are uniform rights of medicine turnover in the Union, and will we be able to convince other countries to create this mechanism also? This is a big question mark. As for the position on the list of goods for parallel import, we here absolutely support the position of Ministry of Industry and Trade, and of course those goods which require registration and registration procedures and audits should not be included in this list. Thank you very much, Olga, for your time, for your participation. And now let me turn to Igor Sobol with a question or with a proposal to share with us your company's successes in the crediting for the pledge of intellectual property rights. It's a new topic for us, and we are really eager to listening to your experience. Thank you, Victoria. I will tell you with pleasure. Could you bring up my presentation, please, if possible? And meanwhile, let me thank Rospatent for this kind invitation to take part in this interesting discussion. And thank you very much for your hospitality of the Center of Healthcare Technologies in Moscow. Well, let me start with the very simple idea, very simple thought, that in the current situation, crediting under the pledge for IP rights is a means of individualization, and this is a tool of including the liquidity and the money where they are needed.
where technologies are being generated that will be able to substitute the departing technologies and create new growth points. In accordance with the civil law of the Russian Federation, the object of pledge could be a wide variety of IP rights, except for those that cannot be alienated: the brand names, the origins, and others. However, talking about successes, I should say that we are one of the few banks that have the experience and expertise of providing pledged loans for IP. But usually, well, I mean, using only IP as a collateral, this is something that our bank can offer. And it is not only about loans, but also some guarantees with IP pledges for the company that took part in a very important public project of R&D. So the IP was used as the collateral for that guarantee. But we are facing several regulatory problems and other challenges. Some of them are being resolved now, but some not. First, that the bank needs to do is to understand whether we do have the proper owner. But here we face the challenge of getting and retrieving information from the public databases that cover IP rights. We have the state registration of real estate and of corporates. Quite a regulated area. There are registers available, there are also rules of providing information, etc. And for the creditors and lenders, it is important that those data are authentic. The concerns that there is no legal regulation of the provision of data from public registers is still lacking, but we do hope that the legislator will hopefully take a look at that. As a rule, if the IP assets are used as a collateral, and if those are not visible for the bank, it means that the bank would be the next turn creditor. That is, if the original creditor would charge a claim to recover the loan, then the bank would be second in that line. The thing is that sometimes the pledge holder does not have the title to the IP assets that are being offered for the pledge. However, we need also to remember that the information about the registration of assets and any registered data would not have very high risks, but they are still there. So if you also individualize and make authentic all those registers, this would be of much help. Another challenge that is still not being resolved, but which will always be with us, this is the valuation of the pledge. You also need to assess the market value of the pledge, and this is a significant and essential part of the contract. But unfortunately, there are some shortcomings, and there are also questions about those shortcomings without any comparisons, and this is driven by the nature of IP activities. How to compare IP assets with analogs, because what is a duplicate and what is the original and authentic product, and the valuation there would be quite uncertain. With the cost method well, I mean, how to compare the costs used for the production of an IP asset. And there, of course, you may expect quite broad and wide forecasts. Also, which is true for the method of trying to assess the future deliverables from IP. Then pledge registration. If IP assets are subject to state registration, it is okay. If not, then the pledge cannot be registered. But totally separately is the story about the registration of a pledge in relation to voluntary IP assets like microchips or software. And of course, the solutions are different. For registration is not available for software assets, although this is not directly following the article in the Civil Code. However, for the lender, the legal protection of the IP assets is closely linked to the registration to avoid the risks of being the next turn lender. And here, in relation to software, the story is quite interesting. Within a month, the Supreme Court came up with two resolutions in 2012, which was about the use of Part 10 of Chapter 2, and a month before that, there was another decision of the Supreme Court, which said that registered can be only the transfer of the title. But in the specific case, the position of the court was quite interesting. The lender at that time took as a pledge some software and appealed to Rospatent for registration and received denial because this is not a function of then the debtor was defaulted, and the lender went to court to recall the pledge. But the court actually said that the pledge really was not about anything, referring to Article 1213 to 32, because there was no transfer of the title. There's a little map here, if you like, which was composed for each of the IP rights in terms of the legal protection of the pledge based on what may be registered and what may not be. And here the databases and software have the same coloring, but you need to really keep in mind what we discussed before. Unlike the goods, the software IP is based on information, and hence you cannot really establish the title based on ownership. So, if I have an apple and I have an apple, we would exchange the apples. We would still have an apple each. But if we have IDs, I have one ID and you have one ID. If we exchange IDs, we then would have two IDs each. And the next thing that I need to probably discuss, thinking about our time, is that the pledge can really be cancelled only on the initiative of the pledge, because the owner of the pledge may want to refuse the payment for the protection or for the use of the trademark, etc. So there you need to balance the interests of the pledge holder and the lenders. The next question is about the call on the pledge. In current regulation, we simply don't have any mechanism or procedure or rules that would allow the lender, when really making a claim on the pledge, to keep the pledge, because then you'll have to also hold some auction. Even in the event when you don't have any other buyers for the pledge, it is still not clear what to do next to such a pledge. And it is important to have such a procedure in place, because for any other property, such a procedure is available. And in conclusion, I should probably recall here something that we think could be done. For example, the software IP assets should be subject to state registration, and this is being done. There's already a draft law of the federal law. You can see the number of this federal law. It has been introduced into the State Duma, and which says that the software IP assets pledged must be registered by the government. We also think that it is important legislatively to formalize the registers of such IP assets, describing their contents, etc., and mentioning that such a register has the characteristics of being an authentic database, and this would really facilitate our handling of the pledged IP assets. We also think it is important to have in the administrative rules of Rospatent to have another rule for the transfer of a pledge, or for keeping the pledge, and also provide for some opportunities for the lender to first introduce a moratorium on the exclusive right of the pledge, and that proposal would be then perceived in the context of the public authenticity of the register, and that would be quite clear. And then the owner of the pledge, if for some reason a startup was not able to pay for the maintenance of the trademarks or the patent in force, then that could be done as an option by the lender. And I would like to thank Victoria for the opportunity to speak here. And if there are any questions, please go ahead. Indeed, an applause is welcome there. If I can add something to what Igor was saying, just a contribution about paragraph 4.1, which says that you need to limit the right to refuse the right to pledge, but you also can issue a letter for the right of registration of the IP asset to a third party, and this can be done. And then it would be almost impossible to contest such a letter. And I recommend that you would take this into account. And Ozortsov, by the way, quoted Bernard Shaw. Yes, thank you. We indeed never thought of that, but in our contracts we do have such a prohibition. Colleagues, thank you very much for your participation, for this lively discussion, and I thank you for really hearing our request and our invitation. All the contributions and deliberations were about very relevant issues for the patent activities, and our session, I think, was quite interesting for all. I really heard a lot of interesting things for myself, and I think the panelists deserve a very loud round of applause. Colleagues, let us also thank our moderator, Victoria. Indeed, all our session here can be moved to St. Petersburg Economic Forum in the same composition, legal forum. I'm moving a little bit to the economic side, so we all can move to both fora, to the legal forum in St. Peter and to the economic one. Thank you, colleagues.